SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. When a criminal case involves very unusual circumstances, a court carries a heavy responsibility to determine what the most just sentence will be. A trial involving a man from the San tribe posed this exact challenge. In our multicultural society, the courts have to assess criminal responsibility by looking at a broad range of factors, including educational background, life experience, and cultural heritage.
It's a very, very interesting case of cross-cultural, two cultures trying to speak to each other through the criminal code. The code is what we say, this is how we should behave in our society. And you've got societies that cover various, very, very different groups. And you have to understand someone's worldview before you know what the intention was and how criminal was that person's behavior. Was it out of step with those in his society or not?
Dalu! Dalu! Aku tadi macam cuma tahu tu kami. Betina! Betina!
Kemana wah?
Hamba cuma mau lah, tadi ni macam tu cuma.
Memang aku dah metu.
Macam tu kama kuang.
Yang cuma kama kuang.
Macam tu.
Anda minggu ku yang anda macam.
Jangan kata jangan kata kau.
Kama kita dah juta kau kau.
Minggu lah tu kan lewat ya.
Macam tu.
Cuma cakap kami. Cik.
Ya.
Kau amiga, kami kuang tila. Tunami, kusa. Maya, Maya.
The crimes of passion are those crimes where basically we can say they have not been planned or they have not been premeditated.
Crime of passion is usually in the situation of sexual partners where one is so blinded by rage or by jealousy that you are totally overcome in such a way that your guilt is not there.
It takes away the objective thinking of an accused person, and one would simply act within a twinkling of an eye, split of a moment would act. Then that's why the court would always, when looking at this type of a crime, would find that indeed there are compelling reasons, at least that mitigate this type of an offense in favor of the accused person.
Katunga was found guilty of the murder of his wife. Because he had been granted bail, he was under the mistaken impression that he had gotten away with the crime.
Hierdie is eintlik 'n sosiale besoekie, meneer Katunga. Ons is hier om die vonnis te bespreek.
Vonnis?
Ja, jy is vrygelaat op borgtog voor jy saak voorgekom het, maar jy is skuldig bevind.
Met ek was ek ja. Ding ou met men me wachu.
Ampa, junge tu ke ngakan dia takkan la juga thongai ka wachu. Je tro ka ke kwanja.
Minda ba? Takula me wona mari o kandwa.
Ci troviselam ke trengo tu ke wakan dia takkan le ke tla ko mali. Ta juga thongai ka diwi wachu. Ci trovisisi.
Ek is nie vriend.
Jy is skuldig bevind aan moord, meneer Katunga. So nee, nie presies nie. Ons het nog so 'n bietjie van 'n pad om te loop.
Ja, ke itane ne gyang ola. Da kadang tang se tane ya sumpa wa ngacin ola wa chondoa. Da tasim.
Kada ganti ji teme. Dan nog aan me klama kada gamanem chimata ke.
Die hof sal besluit vir hoe lank jy tronk toe gaan.
Tronk? Kan net maar.
Die hof kan vir u 'n vonnis oplê van lewenslang. Bedoel 25 jaar.
Kau dadam Kauna domaka nakanga namaka magwazi magmaka tuwa kaya durungo.
Ampa, yang amsa ciri hanga.
Aja kawasan nguna tami kimin kula. Madam timaka gagwan kami.
Meneer Katunga, ek sal probeer om vir u die kortste straf te pleit.
In sentencing an accused person, some of the crimes, there is an ordained sentence or a minimum prescribed minimum sentence. But the legislature would still at least allow the court to exercise its discretion by saying you can find and see if there are any substantial and compelling circumstances that will make this honorable court to deviate from what is ordained or prescribed by the legislation.
Coming up, will Katunga's defense be able to convince the court that there are substantial and compelling circumstances allowing for a departure from the minimum sentence for murder? The Criminal Law Amendment Act provides for minimum sentences to be imposed in cases where an accused is proved to have committed certain types of serious offenses, including murder. The court that decides the appropriate sentence can depart from the guidelines where there are substantial and compelling circumstances that exist which justify the imposition of a lesser sentence.
In looking at this, a variety of issues will be considered. Of course, the age, the level of education of the accused person, the circumstances surrounding the particular offense.
My lord, the accused is a highly unstable and clearly disturbed individual. And due to the vicious and aggressive nature of his crime, clearly poses a threat to the community. Who is to say he will not suffer another hysterical outburst and take the life of another unsuspecting victim? If the accused was an elderly man, the court would concede to a lighter sentence. I will put forward evidence that will prove beyond reasonable doubt that he is in fact younger than he claims.
Edele, meneer Katunga het 'n lang en harde lewe gehad. Hy het oor 1000 kilometer getrek oor Afrika vanuit sy geboorteland Angola om van die gruweldade van die oorlog te ontvlug en om vir asiel te soek. En gedurende hierdie tyd het hy van die grond gelewer en ontberinge gehad wat veel minder mense al ooit gehad het. En as gevolg hiervan het hy geen verbintenis met die moderne wette en gemeenskappe nie. En ek kan nie verstaan die logika agter ons westerse leefwyses nie. En ten spyte van die geïsoleerde insident was hy 'n rolmodel. 'n Goeie man. Iemand wat omgee. Hy het sy afhanklikes lief gehad.
The age of Katunga in this case was of significance because, firstly, it will have served very little purpose to further sentence Katunga for a long period of time, in the sense that would not really contribute to his reformation or rehabilitation. It can actually destroy him, which is not the principle of sentencing. And secondly, the fact that he was of that advanced age and never having committed a crime, it's an indication that what we're dealing with here is a model citizen, even if he was living parallel to society.
Hy is geen bedreiging vir die samelewing nie en ook nie vir sy gemeenskap nie. Om die waarheid te sê, sy familie en die familie van die slagoffer het beweer dat hulle hom vergewe het en het selfs bygedra om sy borgtog te betaal.
I think the court took note of the fact that the victim's family had contributed to bailing him out. And that was a very, very unusual fact, actually. And I think that in itself would have been sufficient for him to know that there's already reconciliation taking place. We don't have to enforce it, it's happening.
Section 35(3)(k) of the Constitution states that every accused person has the right to a fair trial, which includes the right to be tried in a language that the accused person understands, or if that is not practicable, to have the proceedings interpreted in that language.
Most people are discouraged to approach the courts, when they think of the layout of the courts and when they think that they cannot express themselves. So it is very important for the interpreter to sensitize the community about that they can come to court, and the Department of Justice has actually provided the interpreters, the victims, the accused, everybody to express himself in the language of their choice.
So meneer Katunga, het jy ooit voorheen so 'n woede-uitbarsting gehad?
Katunga, tisaka wa la tsitsake o magang hoi tsia magage ang oling.
La pa titsa ko ka me tama magtwake o. Kamang hoke ngatia oling ka magtwake o. Tama twa ngai ka kuya ka mag akui ka mag ngono ke o la kanga titsa. Ya o ke khmaming ja. Akakwan ngai.
Nooit. Ek was besete. Ek weet werklik nie wat my oorgekom het nie. Ek het inderdaad nooit so opgetree nie. Ek was nog nooit 'n gewelddadige man nie. Ek was nog nooit so nie.
Meneer Katunga, u mag maar afstaan.
The metaphor of evil spirits, I think, is very widely believed, not only in San, but other indigenous societies. It's really a metaphor in the same way as we might say, I was beside myself, or I lost the plot, or something like that. It's really a metaphor.
It is important to learn people's culture, because if you don't know people's culture, sometimes it can be very challenging. For instance, I'm going to give you an example of an African language where they use euphemism. They will address an adult person in a plural form instead of a singular form, because of a respect that they have. So if you don't know the culture of that person, obviously it's going to be challenging, because you shall have addressed or you shall have interpreted the source language in a plural, and only to find that that person has been in a singular form all along.
Ek rig die aandag van die eerbare hof tot die saak van R versus Gal, 'n 1958 uitspraak van die destydse Suidwes-Afrika. Die hof het daardie tyd na die beskuldigde verwys as die boesman wat sy meer verloor het.
I object, my lord, on the grounds that this case is irrelevant to the proceedings today.
Nee, ek is nuuskierig. Ek sal graag wil hoor. Meneer Barotti, gaan voort asseblief.
Dankie, edele. In daardie saak het die beoordeelde sy meer verloor en as gevolg een van sy stamlede met 'n mes gesteek in 'n vlaag van woede. Hy en sy medestamlede het toe voortgegaan om die slagoffer of die oorledene met takke toe te pak. Die hof het beslis dat in die geval van die saanmens van wie die beoordeelde 'n lid was, en ek haal aan, dat dit in hul kultuur is om die moordenaar sonder straf te laat gaan. En dus het die hof 'n vonnis van 3 jaar tronkstraf met harde arbeid voorgelê. Ek stel voor dat hierdie saak verteenwoordig 'n soortgelyke feite, in dat dit reflekteer die kultuur van die saamgemeenskap, en dat die moord in daardie geval ook 'n misdaad van passie was. En ek smeek die hof om 'n soortgelyke opskorting aan te wend.
My lord, it is my submission that in this case, which he refers to, is very different to the case before the court today, and the facts are not similar enough to justify a similar sentence to the one that was handed down in that case. which was heard by the Namibian High Court some 53 years ago. I therefore submit that your Lordship should not apply this case as precedent for the appropriate sentence for the accused, as the set of facts before us today is most certainly distinguishable.
Ek stem saam met Juffrou Malan. Hierdie saak ten spyte van dat die beskuldige van 'n soortgelyke kulturele agtergrond kom, het dit geen melding of relevantie teen die saak vir ons vandag.
The court, firstly, when deciding each and every case, just to make work easy, simply and efficient, will look first as whether is there any particular case with similar facts or maybe a principle which is called a precedent.
It's important to note that some of those cases are distinguishable. What that means is that the facts in those cases are very different, the circumstances are very different.
In this case, the judge distinguished those cases and said they don't apply. And I think he was trying, in doing so, he was trying to say, because you're a San person doesn't mean you can do whatever you like.
Coming up, the state prosecutor and defense give their closing arguments and the judge delivers his final verdict.
My lord, the state concedes that if the accused age is more than 60, combined with the fact that he is a first-time offender, has suffered many hardships, and has a certain level of unsophistication, a sentence of life imprisonment would be unjustified. The accused claimed that he does not know his own age, yet on his official identification document, he is 58.
Edele, ek lê beswaar aan dat die sogenaamde identifikasiedokument 'n bewys is van die beoordeelde se egte ouderdom. Op grond van al is dit tegniese amptelike dokument, dit in twyfelagtige omstandighede uitgereik is.
Asseblief, gaan voort meneer Barotti.
Daardie identiteitsdokument was uitgereik gedurende apartheid. Wanneer, soos wat ons weet, ten spyte van die apartheidregering se bureaukrate se obsessie met rekordhouding, die ouderdom van stammense dikwels beraam was deur die amptenare. En dis nie op feite gebaseer nie.
Is daar enige ander dokumente wat voorgesien kan word as bewys van sy geboortedatum?
Nee, sy ma het geboorte gegee op haar tuisdorp in Angola. En dit was nie normaal om geboortesertifikate daar te kry in daardie tyd nie.
Wel, is daar iemand ouer as hom in die gemeenskap wie kan getuig tot sy ouderdom?
Nee, edele. Maar as hy 58 was, dan sou dit beteken dat hy net 11 jaar oud was toe hy sy vrou swanger gemaak het met hul oudste kind, of hul eerste kind, wie nou 47 is.
Dankie meneer Barotti. Ten spyte van dit biologies moontlik was dat meneer Katunga sy vrou swanger gemaak het teen ouderdom 11, vind ek dit hoogs twyfelagtig. Daar is ook geen bewys van hoe vertroulik die geboortedatum op hierdie dokument is, of hoe dit beraam was nie. Die verdediging het dit reg gekry om twyfel te lig aangaande die waarheid van die dokument en sal dus buite rekening gelaat word as bewys. Mevrou Malan, het jy enige ander bewys of getuies wat miskien kan getuig tot die ouderdom van die beoordeelde?
Nee, edele.
Dan in die lig van die ander informasie voor die hof, beraam die beskuldige tussen 61 en 63 jaar oud.
Court has got a discretion if the age of the accused person in sentencing proceedings is in dispute.
The court may look at the circumstances of somebody's birth, and that may, like in this case, look at the firstborn of the accused, look at the age of the brother of the accused, and like in many areas in the rural areas, the court may look at even the event around which it is alleged that a person was born. For instance, other people were born during the Second World War or First World War or the Great Depression, and you can be able to link the years during those periods.
The next day, the courtroom waited in anxious anticipation to hear the judge announce his decision on the appropriate sentence to be imposed.
Na oorweging van al die faktore voorgeleë deur die verdediger en omstandighede van versagting en verswaring, sowel as die ernstigheid van die misdrijf, is ek te ruste. Dat die substansiële en dwingende omstandighede in te waarheid bestaan en dat met alles saamgesit dit 'n minne van vonnis moord regverdig. Hierdie is 'n grenslynsaak van 'n misdaad van passie en die beskuldige, wesende van dat hy is van 'n relatiewe gevorderde ouderdom. Hy het 'n harde leeftyd gehad en is ongeletterd en ongefistikeerd. Voordat hy die misdaad gepleeg het, was hy van goeie menslike status. En hy is ook 'n eerstydige oortreder. Ek vind dit onwaarskynlik dat hy weer gewelddadige misdaad sal pleeg. Van my perspektief af, om oor 1000 kilometer te loop in die beskuldige se skoene, van sy geboorteplek in Angola tot in sy asiel in Namibië, om skeiding te kon vind in sy aangenome land Suid-Afrika, is die volgende vonnis gepas. Meneer Katunga, u is hier neergevonnis tot 8 jaar tronkstraf. Waarvan 3 jaar daarvan opgeskort is vir 5 jaar onder die omstandighede dat jy nie weer beskuldig word vir 'n misdaad in betrekking met geweld teen 'n ander persoon.
The court obviously was influenced by the fact that for as long as Katunga has lived, for the plus minus 62 years, he has never committed any offense, and also that the offense that he has now committed is an offense that was not a premeditated offense.
One of the sentencing requirements are deterrence. When you're sentencing someone, you want to deter others who are thinking of killing their own wives because they're suspecting something. So if you gave a very tiny sentence, of course, some people in theory might be encouraged to think, well, that sentence is so small, I'll risk it. So that part of the balance is you have to deter others, but you have to give retribution of some form for those who have lost, but there should also be possibly reformation and conciliation, and that was what was quite high, I think, in this judgment.
The constitutional right to a fair trial guarantees an accused person the right to be tried in a language that the accused person understands, failing which, the right to have the proceedings translated into that language. A court can depart from the minimum sentences for serious offenses in cases where there are substantial and compelling circumstances allowing for this. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.